felt the biggest problem was the logic of it all. Logically, a prosecutor cannot know what is exculpatory, what's helpful pursuant to our theory of the case. They don't know our theory of the case, and just as we cannot guess what is going to be useful to them in their case in chief. So that's really what we had to start focusing on. Of course, if the motion to compel didn't get it done, we ended up dealing with motions to exclude quite often with all the representatives, and really it was a slower system. We had to look at the practicalities of it. It was slower. It was more expensive. The community had questions and kind of didn't have the confidence in the system that the system does deserve, and that we thought it should and in fact can have again. So as Dave was saying a minute ago, he kind of brought up the points of the prosecution to protect the witnesses and the victims, and that there was compliance with Rule 16. What we had argued was clearly, and most of you have made this argument, is that we've been unable to adequately prepare our cases. We've heard the term kind of trial by ambush from both sides, and we realized that we don't want ambush in the system anymore. We don't want gamesmanship in the system. It does not help either side. It does not help to fairly adjudicate a case. The expenses that were incurred, and Tim Young from the Ohio Public Defender's Office, I felt, did a nice job talking about the expenses in this case. Without the free exchange of evidence and information, material in these cases, the amount of time necessary to go back and forth to these pre-trials, the amount of time necessary to do your own independent investigation when in fact it may just be there in writing, it costs our system, it costs the clients too much money. Tim oversees the state budget for appointments and has to approve off on that, so he was very clear that the closed discovery system really taxed the state budget. Rights to a fair trial, I mean, how many times has that been an issue on appeal? That's constant. And of course the Sixth Amendment implications and our ability to adequately represent our clients clearly were at issue in this debate. So what we did, once the issues were out there, and it had always been, I looked back through the legislative records and the records of these debates that have been going on now for decades, and it really, that was it. It was limited to this. They said this and they said that, and that's about how close this debate was getting for several decades. And so it was only when we had to start looking at it to see what we could agree on and not necessarily what we had to disagree on. And what we found is that we were actually a lot closer than we had thought. And one of the rules that I drew upon and that the OACDL drew upon in kind of crafting proposals was the rule in Montgomery County. There are Montgomery County lawyers here. Okay, so several of you guys. And my understanding through Tim was that everything works. I've practiced there and I hadn't had a problem with it. So that is what we started to look at. The calls for open...
Just as a postscript to the Montgomery County rule, for those of you who don't practice there, it was declared unconstitutional in State versus Lambert and is unenforceable. The only reason it works in Montgomery County is the defense bar, the prosecution, and the bench have all pretty much bought into the idea. But the ability to impose the Montgomery County model on the rest of the state, which was really the 1995 genesis of that effort, was pretty much deemed to be unworkable from the prosecutor's side.
That's exactly right. The local rule, it was just more suggestion and not something you must follow. But our thought was that it works, and by all reports, there was agreement in that. So the calls for open discovery really kind of started most recently with Cuyahoga County. And we looked at Cuyahoga County, obviously as the largest of the 88 counties. It was a closed discovery jurisdiction, and we felt that that would be the kind of right testing ground to see if it worked. We thought that it would be good because during the pendency of these discussions between the OPA and the OACDL, it would be nice in that time to eliminate speculation and say it will be fine. If we had kind of a working model in a larger county to say, look, open discovery's been operating, there have not been any deaths, there's not been any increase in retaliation, so on. So that's really why the focus was there in Cuyahoga County.
Let me add that one of the problems we have in our discussion is this question of quantifying, is there more, is there less because of open discovery? The fact of the matter is, when my victim of domestic violence has been intimidated, I don't know why she wants to drop the charges. She generally, if she's afraid of the guy, she's not going to come to me and say, hey, look, I was just threatened. Do you want to take that to grand jury for an intimidation charge? She just stops talking to me or sends a letter that says that they've worked things out. So drawing a causal relationship in this kind of underworld sort of activity with multiple different variables is virtually impossible. The prosecutors, because of the work that we do on a daily basis, feel that it's a not pervasive, but a real and significant problem if we have no discretion to do any gatekeeping. Obviously, the defense bar feels that it's a much smaller problem. I think we agreed that there was some grounds that it did happen sometimes, and we needed to address that in the rule, which we did.
I agree. It probably is easier to quantify the violations of discovery. I mean, you see the appeals, you see exonerations and so on. It's easier to do that probably than determine, as Dave said, who's been intimidated, who has not. And these are some of the things that we really needed to discuss to understand the other side. That's not something that we on the defense side were able to see. And so these were some of the issues that we had to get past. So in Cuyahoga County, it did go into effect, Rule 23.1, Open Discovery Rule, February 10th, 2009. It is electronic in Cuyahoga County. We have what's called a portal system there. We still file our discovery as normal. Just like the Montgomery Rule, it is something that cannot be enforced, but everyone has agreed upon it. The judges voted on it, passed it overwhelmingly. It's 33 votes in favor, 1 vote in opposition to it. But most people have been pleased with it. It certainly has. It's got to work out the kinks. But the portal system means that you are getting everything, all police reports, witness statements, all evidence on your computer. That's coming right into your office. And so it's been a very nice system. It's been efficient. It has already shown a decrease in the number of pretrials necessary. And we have not had a study yet to show whether or not the pleas have been increased or trials, those numbers. We're going to need a little more time to get that. But right now we've not seen any major problems. And from those that have kind of been the test group or the vocal test group from the defense side, so far they're pleased with it. I've seen several Cuyahoga lawyers here. Is there anyone who's seen any major problems with it? Okay. So what we started to do once this was in place, we kind of brought this into the discussion, our discussion as well with the OPAA. Now, this was an article back in December of 2008, and this was kind of